Hi, everyone, and welcome to the second panel, the Environmental Legacy panel. Unfortunately, we have a little hiccup with our moderator, Jenny Rushlow, but she will hopefully be joining us shortly. But to get the ball rolling, Hi, everyone, and welcome to the second panel. To introduce our speakers. First, we will have Miss Mary Greene, who works with the National Wildlife Federation, and she'll be talking to us about the Mineral Leasing Act. And she'll be followed by Professor Joel Mintz, who works with the NOVA Southeastern University Shepard Broad College of Law as a Professor Emeritus of Law, and he'll be discussing the regulatory and enforcement rollbacks with the EPA. And then Hannah Perls with the Harvard Environmental Energy Law Program will be zooming in a bit with the Clean Air Act. And then to wrap everything up, we're going to talk with Sandra Zellmer, who is a professor of law at the University of Montana, Alexander Blewett III School of Law. And she will be discussing the executive fiat as exercised by Teddy Roosevelt and Donald Trump. So looking forward to it. And Miss Mary Greene, if you could take it away.
Great. All right. I'm going to quickly share my screen. So hopefully, no. Okay, great. So I'm excited to be here. I am going to be talking about the legacy of the Trump administration's energy dominance strategy as seen through oil and gas leasing on public lands. And then I'm also going to talk about a few ways a new administration can work to change what I think is a fairly broken system and the changes they can make absent any significant legislative change. So the last 4 years have really made clear that changes to the oil and gas leasing system are needed. I mean, it's highlighted problems in the way our public lands are managed, and specifically in the way land is made available for oil and gas development by the Bureau of Land Management. Now, admittedly, many of these problems have existed for years. For example, in my mind, the Bureau of Land Management has improperly prioritized oil and gas leasing in many, if not all, past administrations. But these problems really came to the fore under administration that didn't just prioritize energy development, but pledged energy dominance. And because of this pledge, we saw oil and gas leasing occur at a pace and a scale that we've really never seen before. Between 2017 and 2019, the Trump administration offered a staggering 24 million onshore acres for oil and gas lease sales, 5 million of which were sold. In contrast, between 2014 and 2016, 8 million onshore acres were offered for sale, 2 million of which were sold. And the issue that we saw, it wasn't just the pace and scale, it's also where we saw oil and gas lease sales occurring in these past 4 years. We saw leasing or attempts to lease in pristine areas that were really once thought off limits, and there are just sort of many examples of this. Luckily, public outcry in some of these areas, such as the Ruby Mountains and in and around Moab, led to deferrals. But in many other areas, it did not. We saw thousands upon thousands of acres leased across the West in areas that were known for their rich values, whether they be cultural, environmental, or recreational. And as many of you, I'm sure, know, in the waning days of the Trump administration, the BLM absolutely rushed through a lease sale on the coastal plain of the Arctic Wildlife Refuge. And then on top of existing problems that sort of fundamentally allowed these rampant lease sales to take place, we saw an administration that attempted to erode any environmental safeguards in place to protect certain land from development. And these attempts range from minimizing environmental review to eliminating public comment requirements and shortening protest periods during oil and gas lease sales. And all of this really aimed to minimize public pushback. Now, a number of these actions were successfully challenged in court, but these challenges did very little to sort of divert the administration's seemingly singular focus on energy development and its attempt to push through as many lease sales as possible. And the real tragedy here is that these lease sales in these pristine areas and really everywhere will have lasting impacts for decades to come. They'll damage public lands, degrade habitat and water and air quality. In fact, according to a study from the Wilderness Society, development of these leases could result in life cycle emissions between 1 billion and 5.95 billion metric tons of carbon dioxide equivalent. The leases that are issued under the Mineral Leasing Act are granted for a primary term of 10 years, but this term is extended indefinitely as long as a lease is producing in paying quantities. And once issued, a lease conveys certain rights of development, and it would be incredibly difficult for the administration to take away these rights. Now, admittedly, these rights do come with stipulations attached, sort of such as how and where development can occur on any given lease, but fundamentally they are rights that are conveyed. So essentially, once a lease is issued by the BLM can regulate how the lease is developed, but it cannot really regulate whether the lease is developed. And so as a result, there is really little that can be done administratively to alter the outcome of leases that have been issued legally. And I say legally here, just with the caveat that there have been a number of court cases challenging the issuance of leases under the Trump administration. In Montana, the court actually vacated a number of leases across thousands of acres in sage-grouse habitat. And there is a coalition that is challenging the legality of those lease sales in the Arctic. However, absent this type of challenge, it would be very difficult for administration to take away rights that have been conveyed. So then the question is, what can an incoming administration do to create real and meaningful change in the way our public lands are managed, and really to shift the focus away from oil and gas development? So as many of you know, we've already seen a start to this. On January 27th, President Biden signed an executive order that paused oil and gas leasing in the public lands. Now, I just want to say here, despite there has been a significant outcry and concern over this pause, the executive order does not impact leases that have already been issued. There are currently close to 24 million onshore acres of public lands that are under lease, and only half of these have been developed. The developed leases will continue to produce oil and gas, and the undeveloped leases can still be developed. So the reality is oil and gas on public lands is not really going anywhere anytime soon. It's more a question of how we move forward with leasing the non-leased lands. So under the MLA and FLPMA, which is the Federal Lands and Policy Management Act we'll talk about shortly, it is really unlikely that absent legislative action, the administration can entirely end oil and gas lease sales on public lands. And this is just largely due to their statutory language. The MLA clearly states that, among other things, deposits of oil and gas and lands containing such deposits owned by the United States shall be subject to disposition. And similarly, FLPMA notes that the Bureau of Land Management must manage lands in ways that recognize the nation's need for, among other resources, domestic sources and minerals. So even though an administration cannot likely end leasing entirely, however, it does have discretion to significantly reduce leasing on public lands and reframe how leasing occurs. For example, at the end of this pause, we could hope to see leasing perhaps in areas that have already been damaged, and efforts to protect those areas and values on public lands that have not yet been damaged or should be protected and restored. And I'm going to just talk about a few ways this can happen. So first, under the Federal Land and Policy Management Act, which you'll hear me refer to as FLPMA, BLM can limit lands that are open to oil and gas leasing. So FLPMA governs the way in which public lands are administered by the BLM. It requires the BLM to manage lands under a multiple use sustained yield mandate. Basically, the multiple use sustained yield mandate requires BLM to weigh both environmental and economic values of our public lands, and also consider the present and future needs of Americans. As the Supreme Court said in Norton versus Utah Wilderness Alliance, multiple use management is a deceptively simple term that describes an enormously complicated task of striking a balance among the many competing uses to which land can be put. So in order to meet these goals under FLPMA, the Bureau of Land Management is tasked with inventorying its public lands and developing land use plans for these inventoried lands. And land use plans are developed on a regional level by regional field offices covering the lands they manage. And every single decision that the Bureau of Land Management makes has to be consistent with the underlying land use plan. So this is key. And because included in the land use plan is a determination of what lands will be open to oil and gas leasing. And land use plans often last for decades. For example, we are just now seeing updates to some land use plans that have been in place since the 1980s and 1990s. So these land use plans can play a key role in shifting focus of land management from oil and gas development to other resources, because FLPMA is imbued with discretion over how BLM manages the lands it oversees. Up until this point, the BLM has really been reluctant to rely on this discretion to focus management on public lands that are on values that are other than energy extraction. And this is really made clear by the amount of land that is open to oil and gas development. Currently, over 90% of the 240 million acres of land managed by the BLM are open to oil and gas leasing. And really, under the Trump administration, we saw a number of LUPs released that further reduced sort of already meager protections in place. For example, a land use plan from Lewiston in Montana opened about 95% of our lands to oil and gas development. So a really significant step towards shifting away from oil and gas would be to close more lands to oil and gas leasing at the land use plan stage. And BLM, as long as it provides a reasoned explanation for its decisions, certainly has the discretion to do so. As the 10th Circuit said in Richardson v. BLM, it is past doubt that the principle of multiple use does not require BLM to prioritize development over other uses. Accordingly, BLM's obligation to manage for multiple use does not mean that development must be allowed. So I do want to make it clear that under FLPMA and the land use plans, just because lands are open for oil and gas leasing, it doesn't mean they will necessarily be leased. We certainly don't see 90% of the 240 million acres leased. There are a number of steps, and we'll talk about this shortly, that BLM must take before it actually determines which lands it will lease. However, closing lands at the LUP stage is sort of the clearest way to prevent any development in the future, because all decisions must comply with the land use plan. And if lands are closed, they cannot be leased unless the land use plan is changed. So if we see another administration come in and attempt to erode environmental review and public input, it would still be bound by the LUP. And while indeed that administration would have the opportunity to change the land use plan, it does take a long time to finalize and make these plans. In fact, under the Trump administration, we saw a number of changed land use plans, but the large majority of the oil and gas lease sales actually occurred under previous land use plans. And so the fact that the land use plan does take a long time to finalize does provide us with protection. An administration can't just come in and immediately undo protections. But it also means that we're not going to see these lands closed off tomorrow. However, BLM has another tool it can use. It has also significant discretion in the decision it makes over what lands to actually lease. And it could more actively exercise this discretion. So BLM is not obligated, as I have said, to lease lands that may be better managed for other uses, even if they are designated as open under the land use plan. The Mineral Leasing Act largely dictates how BLM leases land. And there are two key parts pertinent to this discussion of the Mineral Leasing Act that really sort of delve into this discretion. The first, the Mineral Leasing Act states that all lands subject to disposition, which are known or believed to contain oil or gas deposits, may be leased by the Secretary. So clearly the authority to lease lands is discretionary due to the term may. And second, the phrase believed to contain oil or gas deposit actually arguably limits that discretion because it prevents the Secretary from leasing lands with no known deposits. Despite this, BLM regularly leases lands with no to very low potential for oil and gas development. And the issue of leasing lands on no to low potential lands is sort of really this discussion of an entirely another presentation But I will just say here, this practice has significant problems. It allows oil and gas companies to lease lands through a non-competitive process at extremely low rates. And when I say extremely low, I'm talking about $1.50 an acre. And then even if the lands are ultimately not developed because they are low to no potential, the presence of these leases often prevents BLM from managing that land for wilderness or other values. And so arguably, BLM could really stop this practice tomorrow of leasing lands with no to low potential for oil and gas leasing. Now, BLM often pushes back against the notion that it has discretion at the lease sale stage by pointing to statutory language that was added to the Mineral Leasing Act in 1980. And this language says, lease sales shall be held for each state where eligible lands are available at least quarterly and more frequently if the Secretary of the Interior determines such sales are necessary. However, the statutory language clearly states where eligible lands are available. And what I am arguing here is that BLM has the discretion to determine which lands are available. Up until the point at which a lease is actually issued by the BLM, courts have time and time again upheld this discretion. For example, the Supreme Court in Norton stated, a land use plan is a tool to project present and future use. Unlike a specific statutory command requiring an agency to promulgate regulations by a certain date, a land use plan is generally a statement of priorities. It guides and restrains actions, but does not prescribe them. And finally, I would actually argue that a clause in FLTMA known as the unnecessary or undue degradation mandate actually limits BLM's discretion in the other way and prevents BLM from leasing certain land. FLTMA requires that in managing the public lands, the Secretary of the Interior shall, by regulation or otherwise, take any action necessary to prevent unnecessary or undue degradation of the land. So arguably, leases that would cause unnecessary or undue degradation should not be issued. There hasn't actually been a lot of case law about this issue, but there are two cases that uphold this notion. The 10th Circuit in Sierra Club v. Holdall found that the unnecessary or undue degradation mandate does impose a definite standard on the BLM. And finally, the DC Circuit in Mineral Policy Center v. Norton stated that FLTMA, by its plain terms, vests the Secretary of the Interior with the authority and indeed the obligation to disapprove of an otherwise permissible mining operation because the operation, though necessary for mining, would unduly harm or degrade the public land. Now, Norton was arguably about mining, however, it would pertain to oil and gas leasing as the undue degradation mandate extends to leasing. So in conclusion, the Bureau of Land Management has significant discretion to determine where and how public lands should be leased, and it should use this discretion. It should rely on this discretion to restrict leasing, to embrace the concept of multiple use sustained yield, and to reject the notion that oil and gas development should be valued above other uses of public lands. And I will end it there.
Okay. Well, the article I wrote for this symposium is titled Rolling Back and Losing Ground, EPA Regulation and Enforcement in the Trump Era. In the next 10 minutes or so, I'll focus on three topics. First, Trump administration regulatory changes at EPA. Second, critical developments and trends in EPA enforcement during the Trump years. And third, suggestions for ways that the shortcomings of the Trump administration's policies can be ameliorated in the Biden administration. The Trump administration rolled back pre-existing EPA regulations in a wide range of critical areas, including air quality, water quality, toxic substances, pesticides, and protection of endangered animal species. After overviewing those rollbacks, my article focused on three illustrative policy reversals during the Trump administration. The first Trump EPA regulatory change I examined was the agency's rollback of vehicle mileage emission standards from from the levels that had been established in the Obama years. The Trump regime's reasoning for this rollback relied on two extremely questionable assumptions, namely that auto manufacturers will automatically spend less money on research and development for vehicle safety if they have to meet stricter vehicle mileage standards, and secondly, that consumers will certainly spend all of the money they save from weaker emission standards to improve the safety of their own cars and trucks. Really a very questionable idea. In relaxing vehicle mileage standards, the Trump administration completely ignored the careful scientific research that had been conducted during the Obama administration, and in doing so, they made a contribution to global climate change and more conventional air pollution problems. The second Trump-era regulatory change I analyzed was the Trump EPA's extraordinarily narrow administrative interpretation of the Clean Water Act's jurisdictional phrase, waters of the United States. Its interpretation included only oceans, streams, rivers, and lakes. However, the definition ignored many river tributaries and wetland areas that serve as natural flood control basins, filters of pollutants, and nurseries of many aquatic species. Finally, in this area, my article examined the Trump administration's policy that new regulations that impose costs on industry must be offset by the elimination of existing costs imposed by two prior regulations, the so-called 2-for-1 rule. I argued that this policy violates a provision of the National Environmental Policy Act, or NEPA, that directs that all policies of the United States shall be interpreted consistent with the environmentally protective policy safeguards of NEPA. Interestingly, so far, the Biden administration immediately reversed the Trump 2-for-1 policy, and it announced that it will impose stricter standards for vehicle emissions and that it will expand the administrative definition of waters of the United States. So the latter two changes are sort of in progress at the moment. Turning to EPA enforcement, it's clear that during the Trump presidency, the downward trend in environmental regulation was paralleled by an overall decline in the volume and effectiveness of the agency's enforcement work. EPA reversed the overall pattern of its relationship with state environmental agencies by ending federal oversight of state enforcement in favor of a policy of deference to state enforcement preferences. This approach weakened the nation's overall environmental enforcement efforts because a significant number of states were not equipped with either the staff resources or the requisite expertise to enforce environmental laws effectively. Moreover, a number of states did not have the political will to conduct environmental enforcement. The morale of EPA's professional enforcement staff during the Trump years plummeted. This was due in part to a realistic sense on the staff's part that regional enforcement attorneys and scientists were being intentionally excluded from closed-door meetings with defendants in enforcement cases, meetings that were conducted by EPA's regional administrators. The latter group, regional administrators, generally tended to be conservative, anti-regulatory ideologues with a negative view of enforcement and environmental regulation in general. Also notable was EPA's COVID-19 enforcement policy, which was in effect from late March through the end of August of last year. This policy suspended enforcement of self-monitoring, self-reporting, sampling, laboratory analysis, and self-certification obligations. It was widely seen as a complete suspension of EPA enforcement, and numerous states responded to it by dramatically relaxing their own regulatory policies and enforcement practices. My article cited a number of numerical metrics that document the decline of EPA enforcement during the Trump years. I'll mention just two of those relevant statistics here. In fiscal year 2010, EPA inspected more than 21,000 industrial facilities for compliance. In fiscal year 2019, EPA inspected only 10,320 facilities, more than a 50% drop-off. Similarly, in fiscal year 2011, EPA enforcement compelled private expenditures of $21.3 billion in pollution controls. In fiscal year 2019, that amount fell to only $4.43 billion, from $21.3 billion to $4.4 billion, more than an 80% decline. Turning finally to my recommendations for post-Trump era reforms at EPA, my article made 8 recommendations. Those include appointment of knowledgeable top leaders at EPA who have no ties to regulated industries. Second, rebuilding EPA's foundation of scientific expertise. Third, undoing numerous specific Trump administration regulatory actions and policies. Fourth, asking federal courts to put legal challenges to Trump-era EPA policies on hold while the Biden administration develops good substitutes for the policies in question. Fifth, systematically reviewing Trump-era regulations and prioritizing which ones to eliminate first. Sixth, providing unwavering top-level support for EPA enforcement. Seventh, publicly announcing particular enforcement cases in order to draw attention to them and hopefully to deter other violations. And finally, increasing the number of EPA attorneys and scientists involved in enforcement work. I'm pleased to report that the Biden administration has already implemented the first 6 of those recommendations. It has not yet taken a position as to the last 2. In conclusion, I'd like to note that as encouraging as their first steps have been, the Biden administration appointees are likely to face numerous challenges ahead. Undoing previously promulgated regulations involves a notice and comment process that may be time-consuming, and it's likely that the recalcitrant polluters will seek to delay implementation of new EPA regulations through lawsuits. Despite that, if EPA's new leaders and staff are persistent, transparent, and careful, there's a good chance that the Biden environmental agenda will ultimately be put into place. I'll now stop there to allow time for other presentations and for questions from the audience. Thanks.
Hi, everyone. Thank you, Professor Mintz, for that presentation. It actually sets mine up really well. So similar to Professor Mintz, I'm taking sort of a whole of EPA approach to thinking about what the Trump administration did in the space of environmental deregulation. Quickly share my screen here. Here we go. Great. So similar to Professor Mintz, here I'm looking, really zooming out, what are the key strategies, and in this case, the key legal strategies that the Trump administration used to affect its deregulatory agenda. And my goal for the next 15 minutes is not so much to highlight key rules or memoranda, though I will talk about those. It's to really give you a framework to think about the scope, the truly awesome scope of deregulation that we saw over the last 4 years. And a quick caveat, most of this research really pulls from work that was done by my colleagues, including our former executive director, Joseph Goffman, who is now at EPA. And so if I say something or I talk about a memorandum or a rule or a directive and you want to know more about it, if you just Google EELP and that thing, you will likely find a much longer, more comprehensive analysis. And so I wanted to flag that as a resource for all of you. But diving right in, we organized a lot of what we saw over the last 4 years into 4 key deregulatory strategies. And talking about, but instead of talking about them thematically, we talk about them in terms of legal strategies or policy strategies. The first one is that the Trump administration really systematically sought to undermine EPA's scientific and expert capacities. And here I have a picture of legs, but I just want you to think about this in terms of, EPA's scientific and expert capabilities are truly fundamental to almost everything that the agency does. When you look at their core statutes, the Clean Water Act, the Clean Air Act, they often require the agency to rely on the best available science. And so what the Trump administration did was to redefine who counts as a scientist and what counts as expertise, and truly actually what counts as science. And in redefining those terms and who those people are, it became a really potent deregulatory tool. The next one is to eliminate or weaken public participation mechanisms. Mary touched on this briefly with BLM and reducing shortening the protest periods. And what Mary was talking about there is, it's really not just about ignoring information that's essential for reasoned decision-making on the agency side, but by preventing people from providing crucial information and creating that sort of public check on deregulation, the agency was able to create explicit preferences for the interest of regulated industries over the communities that are often most affected by those industries' activities. The third one, this is one of my favorites, avoiding regulation triggering events. I don't know if you can see the little picture, but it's neural networking. It's a little cartoon that I like. But I want you to think of this as, really removing the triggers that typically exist as part of policy or decision-making that tell the agency that additional environmental review or regulation is required. And if you can prevent those signals from actually reaching the agency, then you preordain a deregulatory outcome. And the last one, with this sad guy and his short ball and chain, this was really a risky legal strategy that the Trump administration fully embraced with the goal of permanently, limiting the agency's own statutory authority. And they did this, especially at EPA, by adopting novel interpretations of their own statutory mandates to severely narrow, or in some cases abdicate, their own authority to regulate, with the hope that federal courts would approve of that strategy as part of a Chevron analysis, and in doing so, limit all future administrations from trying to pursue a more expansive interpretation of these statutes. So I'm going to quickly go through sort of the key steps that form part of these strategies. And again, I'm going to sort of blow through some examples. In the article, I dive into these a little bit more. And again, if I mention something where you want to learn more about it, ask in the questions, but also you can find more on our website. But with that first strategy, undermining EPA's scientific and expert capacities, they being the Trump administration, really did this in 3 key ways. First, and really the simplest, is blocking the collection of information that's needed to justify future regulation. They did this by stopping or halting or defunding Obama-era studies. For example, they halted a study on the public health impacts of mountaintop removal in Appalachia. But they also did it by disbanding groups that were responsible for the ongoing collection and assessment of information. And probably the most well-known is the Interagency Working Group on the Social Cost of Greenhouse Gases. Former President Trump issued an executive order that disbanded this agency created under President Obama. This was ultimately reversed by President Biden on day 1. But even though it was reversed, I want to emphasize, those are 4 years of lost data. And so when the Biden administration comes in, they're not only trying to issue new regs, but they're also making up for 4 years where we're missing crucial information, crucial science that would have otherwise been invested in and developed. The second one is undermining the integrity of scientific review committees. And this is really crucial. Often bodies like the Clean Air Scientific Advisory Committee or the CASAC or the Scientific Advisory Board, the SAB, these bodies are fundamental to how EPA makes decisions. And they also provide crucial checks on deregulatory ambitions within the agency. And what the Trump administration did, among many other efforts, was they blocked EPA-funded scientists from serving on these advisory committees in the name of a conflict of interest. I'm using air quotes, but you can't see my face. But the thing about this directive is it didn't impose a corollary restriction on scientists who come from regulated industries. And as a result, you saw a 25% drop in members affiliated with academic institutions on these committees and a 60 to 70% turnover rate just in the first 2 years of the Trump administration. The last one, the Trump administration sought to block EPA from relying on critical public health studies. This, of course, is the secret science rule that was ultimately just struck down by a federal court in the District of Montana, but it sort of further emphasizes part of this broader strategy to prevent EPA from being able to rely on really important health studies that link exposure to pollutants to public health outcomes, in the name of this broader deregulatory agenda. Jumping to the second strategy, eliminating or weakening public participation mechanisms. Again, they sort of did this through 3 key ways. The first was to restrict meaningful consultation with affected communities. This includes the shortening of protest periods, as Mary mentioned. It also includes sort of more nuanced changes within the administration. Some of our colleagues, for example, last year conducted confidential interviews with the Department of Interior and found that political appointees within that agency intentionally limited the number of public hearings that were held per project. And they also intentionally held those meetings in inconvenient locations, again, so as to restrict the opportunity for consultation and potentially pushback from communities who would bear the negative impacts of these projects. The second one is to restrict public access to agencies' documents and decision-making. And here, we're really talking about the Freedom of Information Act, which is a fundamental transparency tool that allows the public to inquire into agencies' decision-making. And here, EPA, among many agencies, finalized a rule under FOIA that did 2 things. First, it created a bottleneck that required all FOIA requests to go through HQ before they were all handled at the regional EPA offices. And it also designated a political appointee with the power to determine which sections in those requested documents were responsive to the request. And responsive is not defined. And so it gives political appointees an incredible amount of power to either hide or not aspects of these documents and thus aspects of internal decision-making. The last one is more about accountability. And here, EPA restricted pathways that the public typically use to challenge EPA decisions. One way they did this was in October 2017, Administrator Pruitt, before Administrator Wheeler, he issued a new directive, ironically called Promoting Transparency and Public Participation in Consent Decrees and Settlement Agreements. And what that directive did is it required EPA to first consult regulated parties, so here we're talking about states and industry, before they reach settlement agreements. But again, there was not a corollary requirement for EPA to consult frontline communities, fence line communities, folks who would be impacted by these settlements. The other thing they did that is really fundamental is they require the agency whenever possible to exclude the payment of attorney fees and costs to any plaintiff or petitioner. And this especially affects public interest nonprofits from defending the rights of the public, because if they aren't able to recoup those costs, they're really not able to bring these cases in the first place. The next strategy, avoiding regulation triggering events. This is that picture of neurons networking. So again, they did this 2 ways. First, sort of most simply, by just expanding the number and the types of projects that are exempt from environmental review and regulation. And one of the most obvious ways they did this was a really aggressive expansion of categorical exclusions under the National Environmental Policy Act. And we saw this across agencies. We saw this with the Forest Service. We saw it especially with the Department of Homeland Security in the building of the border wall. And when you impose these categorical exclusions, you are really accelerating projects and exempting them from a much more stringent environmental review that might reveal impacts, it might reveal deficiencies in an analysis, and it gives the public opportunities to comment on projects. So by expanding those projects, you're excluding and minimizing opportunities and checks that would otherwise be in place. The next one, and this is a doozy. I spend a lot of time on this in the article, but I'm gonna breeze through it for the sake of time. Here we're talking about restructuring cost-benefit analysis to minimize the regulatory benefits in that assessment. And here, if you can constrain or limit what types of benefits are included in an agency's cost-benefit analysis, you can preordain a deregulatory outcome by making it seem like the costs imposed of regulated industry far outweigh the public benefit. And they did this a number of ways. First, former President Trump issued a number of EOs, including the 2-for-1 executive order that Professor Mintz mentioned, that elevated cost-benefit analysis, not just as a step along the way towards regulation, but as a prerequisite to justify regulation. Another thing the administration did was to undervalue the future costs of climate change. And this was actually a key strategy that they used to repeal the Clean Power Plan. And one of the ways they undervalue the future costs is by increasing something called the discount rate, which is a representation of the value that agencies place on avoiding the future harm associated with climate change. So for example, if you have a discount rate of 7%, it means the agency believes it's not economically reasonable to spend $1 today on mitigating climate change impacts unless the annual return on that dollar is 7% or higher. And this is compared to a more standard rate of 3%. So by using that 7% discount rate, the Trump administration is revealing an unfounded belief that the future financial and human costs of climate change aren't great enough to warrant implementing common sense mitigation measures today, except in the most exceptional circumstances. The next one is the Trump administration would reinterpret their statutes to exclude something called co-benefits from cost-benefit analysis. And this played a really big role in reversing, reversing something called the MATS rule, the Mercury and Air Toxic Standard under the Clean Air Act. And I won't dig too deep into it. I'm happy to talk about it during the Q&A. But the strategy the administration used consistently and then finalized as part of a cost-benefit rule under the Clean Air Act towards the very end of the administration is to say, unless we're talking about the pollutants regulated under a particular provision of the Clean Air Act, we're not going to count them in our cost-benefit analysis, or we're going to minimize the benefits of reducing those pollutants. And this leads to a really perverse outcome where, say you're regulating hazardous air pollutants from power plants, but in doing so, you're also reducing other co-pollutants like, particulate matter or soot, sulfur dioxide, things that really lead to extraordinary health impacts. We know soot, for example, can lead to pulmonary issues, cardiovascular issues, increased mortality due to COVID, and even increased infertility rates. But the Trump administration said, because those pollutants aren't regulated under the provision we're looking at under the law, we're going to pretend that they don't matter as much. And in doing so, again, you're tilting the scales of that cost-benefit analysis to preordain the deregulatory outcome that you want. And the last one is related, but the Trump administration would arbitrarily disaggregate pollution sources. And so instead of looking at, and this is a simplified example, but instead of looking at a whole power plant, you might say, well, we're going to qualify a source as an individual stack, but still require that the emissions from those stacks meet the same thresholds to trigger regulation. And so by arbitrarily disaggregating these sources into smaller pieces, again, you preordain the regulatory outcome that you're looking for. And the last strategy, and this was probably the most nefarious of the strategies that we looked at, and also something that was uniquely Trumpian in sort of the recklessness with which the agency pursued this strategy. And here, EPA would reinterpret their statutes as unambiguously narrowing agencies' authority. And as I mentioned before, this is a Chevron Step 1 argument. This is the argument that not only is our interpretation of the statute reasonable, it is the only reasonable interpretation. And the agency used this in a lot of its sort of greatest hits. And so we saw this with the repeal and replacement of the Clean Power Plan. This was just recently struck down by the DC Circuit. We also saw it in an interpretive statement abdicating the agency's authority to regulate groundwater under Section 301 of the Clean Water Act. And we also saw it in the withdrawal of California's waiver to issue their own tailpipe emission standards under the Clean Air Act. And again, I can dig more into this. So now that I've given you a litany of bad news, the question is, what do we do now? This is a very simplistic overview, but I also think it's important that we sort of see the forest through the trees and think about not just how do we undo what Trump did, but restore these agencies' core capabilities so that they're equipped to meet the environmental and climate goals that the Biden administration has set. So we're really talking about restoring EPA's scientific and expert capacities, that foundation upon which their rulemaking and policymaking capacities rest. We're talking about aggressively expanding public participation mechanisms and making sure that participation is meaningful. We want to reinstate and also update regulation triggering events to make up for those lost 4 years and ensure that regulation is triggered not at levels that were appropriate in 2016, but at levels that really recognize the science we have now in 2021. And finally, we want to return to a pre-Trump interpretation of statutory authority. And here we have a dog happily on its leash. We're not talking about, leaning into an expansive interpretation of these statutes, right? The federal judiciary looks a little different. The Supreme Court looks a little different. But we can lean on best practices and decades of agency practice that tell us that what the agency is doing is reasonable, has been done before, and is certainly within the bounds of the statute. And that's it. And again, here's our website. If I know I breezed through a whole bunch of stuff, but again, if you check out our website, you'll find a lot more detailed analysis there. And I will stop sharing my screen. Great.
Hi, everyone. Thank you to the Vermont Law Review editors and staff for inviting us all to talk on this subject here today. It's really nice to be able to share our thoughts. I sure wish we were all in Vermont, but this will just have to do. So let me get over here and share my screen. All right, so I've been working on a project related to Teddy Roosevelt, of all things. And in particular for this symposium, I'm looking at issues related to presidential power over public lands and natural resources, drawing parallels and contrasts between Teddy Roosevelt and Donald Trump. So can we draw parallels between President Trump and President Teddy Roosevelt? Well, yeah, I think there are some parallels. So I'm going to step through them, looking in particular at public lands measures and also wildlife measures. So let me first just set the stage a little bit with Teddy Roosevelt. Just over a century after Teddy Roosevelt left the Oval Office in 1909, another Republican moved into the Oval Office, Donald Trump, in 2017. The contrasts between the two are many. At first blush, while Roosevelt was the youngest president to take the oath of office, Trump was the oldest at the time. Also, Roosevelt worked tirelessly to bust up corporate monopolies like Standard Oil, while Trump embodies corporate economic and political power. More to the point, Roosevelt is viewed as one of the greatest conservation presidents in the nation's history, with a deep respect for science, while Trump has been billed as the worst, with a palpable disdain for science, as some of our previous speakers on this panel have indicated. However, several parallels between the two can be drawn as related to executive power in particular. Both Roosevelt and Trump also qualify as flamboyant, wealthy, and markedly different than any president that came before them. Both exhibited a zeal for asserting strong executive powers to accomplish his goals, with little concern for the checks and balances of the other branches of government. In both cases, the environmental stakes couldn't be higher. For Roosevelt, the destruction and outright disposal of public lands loomed large at the turn of the last century. For Trump, a rapidly warming climate is bringing the planet to a tipping point. In a chapter that I wrote for a book called Pioneers in Environmental Law, published in 2020, I examined the lasting impacts of Roosevelt's executive power over federal public lands and wildlife. Here, I will highlight Teddy's creation of wildlife refuges and national monuments, and the subsequent dismantlement of many of those conservation measures by President Trump. The comparison reveals some compelling themes relevant to both conservation and democracy, and helps us draw insights about the role of the presidency in conservation initiatives and counter initiatives, and in democracy, in public participation and due process. So let me just briefly go through a few things that Donald Trump exercised by way of sweeping executive powers, some of which you've already heard about in this panel. Part of the platform that he executed with his strong executive powers dealt with a presidential memorandum, or implemented a presidential memorandum that he issued in 2018 to minimize unnecessary regulatory burdens. So his rollbacks, some of them were by agencies, as you just heard. Some of them were by executive order. All of them were in the name of regulatory rollbacks. A New York Times analysis based on research from Harvard Law School and others that you just heard about counts nearly 100 environmental rules that were reversed, revoked, or otherwise rolled back under Trump. Most were under the EPA, which you had heard about, but at the same time, the Interior Department opened up more land for oil and gas leasing by limiting wildlife protections and diminishing or completely waiving environmental requirements. An EPA spokeswoman said, "We have fulfilled President Trump's promises to provide certainty for states, tribes, and local governments." Many rollbacks, though, were through executive orders subsequent to the first one that I mentioned. In 2017, President Trump signed proclamations dismantling 2 national monuments that had been created by Obama, Bears Ears and Grand Staircase Escalante. This stripped protection from about 2 million acres of public lands that held incomparable cultural, archaeological, and ecological significance. Trump's proclamation slashed Bears Ears by 85%, replacing it with 2 small, disconnected units and leaving the rest open to mining, oil and gas, drilling, and road construction. The tribes and others have sued. Litigation is pending. For President Biden's part, he has issued an order initiating a 60-day review of Trump's orders. He also directed Interior to pause new oil and gas leasing on public lands. So that's just a really brief overview of some of the measures that President Trump had taken by way of exercising strong executive powers. You've heard more about that, and I'm sure you'll hear more about them in different contexts throughout the symposium. So can parallels be drawn between Trump and Roosevelt when Trump is considered one of the greatest conservation presidents? Well, I would say there are some parallels, but there are some great distinctions as well. Teddy Roosevelt came into political power during the years between the Civil War and the turn of the 20th century. Manifest destiny had stripped the West of natural resources and escalated conflicts between settlers and Indian tribes, with tribes suffering horrific losses of life and land. More on that in a moment. Long before he became president, Roosevelt was passionate about the outdoors and outdoor activities. As president, he firmly believed that the federal government needed to intervene before the rivers ran dry and the forests disappeared like the buffalo herds. Among all of his conservation accomplishments as president, he believed that conservation of the natural resources and the public lands was the most important among his domestic agenda. Conservation was more than a political concept to Roosevelt. It was also a deeply personal and moral issue. And under his presidency, the National Forest Service was founded, and 230 million acres of national parks, forests, and federal game and bird reserves were protected. A statute signed by Roosevelt had a wide sweeping effect on the mosaic of federal conservation lands, the Antiquities Act of 1906. The Antiquities Act enables presidents to proclaim historic landmarks, structures, and other objects of historic or scientific interest in federal ownership as national monuments. Roosevelt did not hesitate to take advantage of this new executive authority, declaring many celebrated national monuments, including the Grand Canyon, Muir Woods, and others. The Grand Canyon deserves a shout out in particular. Roosevelt wanted the Grand Canyon to be a national park, but the Arizona contingent, the Arizona Territory, hesitated in large part because powerful interests within that territory had staked claim to the minerals, the rangelands, the water rights, and recreational access. For Roosevelt's part, if Congress and the Arizona contingent were confused about the merits of Grand Canyon's irreplaceable aesthetic values, he would just make them see it. And his approach was to declare something and let the chips fall where they may. Wielding the authority of the Antiquities Act, he bestowed national monument status on the canyon in 1908. With that proclamation, he reserved 800,000 acres and declared them off limits for appropriation and use of all kinds under the public lands laws. The Arizona delegation was incensed, as you might guess, and an individual entrepreneur, businessman, politician named Ralph Cameron, with interests on the south rim of the canyon, sued, challenging the validity of Roosevelt's declaration under the Antiquities Act, but the Supreme Court ultimately decided that the Grand Canyon, as one of the greatest eroded canyons in the world, was undoubtedly a qualifying object of scientific interest under the specifications of the Act. Roosevelt's efforts in using the Antiquities Act transcend his own presidency. Many presidents since him have used the Antiquities Act to create national monuments. President Trump, as you know, unraveled or attempted to unravel many of those larger declarations and more controversial declarations. Let us turn now to Roosevelt's attempts to preserve wildlife. Roosevelt's curiosity about the natural world and his staunch support for scientific management in the name of conservation can be seen most vividly, I think, through his legacy in wildlife conservation. At the age of 8, young Teddy created a national history museum in his bedroom and filled it with all sorts of insects, mice, birds, and other specimens. By the time he was a teenager, he had developed an obsession for birds. By the late 1800s, dozens of bird species were being slaughtered for their feathers for the fashion trade. As president, a particular rookery in Florida came to his attention. Roosevelt was not only sympathetic to the cause of conserving pelicans at Pelican Island Bird Refuge, he was in a position to deliver by wielding unilateral executive power. Upon learning that there was no law that would prevent him from making Pelican Island a bird reservation, Roosevelt issued his now famous declaration, "Well then, I so declare it." With that, he created the first unit of the National Wildlife Refuge System. His agenda with respect to wildlife conservation went beyond birds. In his mind, wild bison were incredibly and incalculably valuable to the collective psyche of the nation. He established the National Bison Refuge in 1908 to provide for a permanent range and preservation lands for a herd of bison. From an ethical and racial standpoint, this was quite problematic because those lands, 20,000 acres, were carved out of the Flathead Indian Reservation and taken from the tribe, despite the fact that tribal leaders had told the Indian agents that they did not want to give up some of their best hunting grounds. The agents said they had no choice in the matter, and a price worth about half of what the land was actually worth was dictated to the tribes. The end of this story, just as a postscript, is that the tribe just this year has been returned to the Confederated Salish and Kootenai tribes on the Flathead Reservation to manage the land and the herd under a COVID-19 and government spending bill. So let us go back to the issue of whether or not there are parallels along with the distinctions between these two presidents who have not hesitated to use sweeping executive powers. Interestingly, before taking office, Trump disparaged his predecessor's executive orders as power grabs, but then in each year of his own presidency, Trump issued more executive orders than did Barack Obama during the same time span. The quantity of Trump's orders are less notable than the content, which included sweeping directives for energy development, which you heard about, wildlife killing, and the border wall. Perhaps the starkest contrast between Trump and Teddy Roosevelt is the use of the Antiquities Act, where instead of designating or expanding monuments, Trump ordered domestic reductions to 2 and significant management changes to several others. In another notable departure from Roosevelt's conservation agenda, the Trump administration rolled back a 40-year interpretation of a policy aimed at protecting migratory birds under the Migratory Bird Treaty Act. First, this was issued through executive and secretarial orders in the Department of Interior, and then it was followed up with some regulations that are now under examination by the Biden administration. Fossil fuel development was subject of executive orders under Trump as well, including the Keystone XL pipeline, which Biden has rolled back through executive orders already early in his administration. Some of the key distinctions additionally are substantive in nature. Scientific management principles were followed by Roosevelt, not so much by Trump. Roosevelt conserved the federal public lands, natural resources, and wildlife, leaving the door open to Congress and future administrations to change course if the public interest demanded mineral extraction or other forms of use or development. But by leaving the land intact, Teddy Roosevelt allowed for wildlife habitat and ecosystem services to survive and continue to be protected by the public, while Trump's orders, by contrast, deplete or destroy lands and resources and foreclose future opportunities. From a procedural standpoint, another key distinction is that Roosevelt was writing on a blank slate. Going back to the quote that I initially provided on one of the first slides, Roosevelt was writing on a blank slate. He was taking unilateral actions, challenging constitutional boundaries in some cases, and in other cases, extending his powers at other authorities' expenses. But he really had very few tools in his toolbox in terms of executive authorities. The Administrative Procedure Act was not passed until the 1940s. And the administrative state, the administrative agencies that now exist in numbers these days, did not exist either in Roosevelt's time. There were very few agencies, the Forest Service being one of the few, and he effectively created it. Trump had the infrastructure. He had the agencies with the technical expertise and the scientific know-how, but he sidestepped procedural safeguards that were provided by the Administrative Procedure Act and that were well in place by the time of his administration. Through the Administrative Procedure Act, judicial review is possible, public participation is enhanced, public opinion can be expressed in a more meaningful way, and those provide some significant checks on sweeping executive powers and the abuse of those powers. By issuing edicts like Trump did, in contrast to Roosevelt, despite the availability of a more robust avenue that utilizes the technical expertise of agencies, all or most of these concerns go unanswered. So with that, I will conclude. If you're interested in the book that I mentioned, of which this chapter on Teddy Roosevelt is but a part, it's called Pioneers of Environmental Law. It's 2020, edited by Jan Latos and John Nagel. Thank you.
Hi, everyone. Can you guys hear me? Okay, I hope so. It says I'm on the air. So I just wanted to introduce myself. I'm Hillary Hoffmann, and I was happy to step in and help moderate this panel. Sorry about the technical difficulties that you all experienced earlier, but it's great to see you, and I enjoyed listening to your presentations. So there are questions flying in from the audience, and I was going to pose a couple of them. So the first question is for Mary, and it's about the BLM's move to Grand Junction and how the author is concerned about how that move is going to affect oil and gas leasing in the future. It doesn't say where, but let's just assume everywhere throughout the country on public lands.
Yeah, I think the move to Grand Junction is just another example of the Trump administration's attempt to sort of limit public influence and to limit the authority of agencies. It really absolutely decimated the BLM. I think probably a lot of you have seen recent articles coming out that 87% of the employees who were asked to move did not move. And in fact, they talk about headquarters being in Grand Junction, but the reality is there are 3 or 4 people in Grand Junction and the rest are scattered throughout the West. So really the effect is it's not just oil and gas, it's everything else that BLM is tasked with managing, and it has decentralized and meant that decisions that are to be made will be made, if they are, locally and not with a holistic view of public lands. But it also just practically means there just aren't people in place now to conduct these environmental reviews, to conduct the necessary reviews in order to manage lands properly. They've lost so many of their employees. So I think it has been pretty problematic, the move.
Great, thank you. So a question for Joel. We've already seen the Biden administration aggressively use executive action to begin undoing the regulatory and enforcement shortcomings of the Trump EPA. These can be undone by the stroke of a pen in the next administration. So what bigger steps, or maybe more permanent steps, could the Biden administration take that would enshrine whatever changes the Biden administration makes to protect them from future administrations undoing those?
Well, that's a fair question. I wish I
sense.
could give a more encouraging. Yeah, it does. I wish I could give a more encouraging answer. I mean, to the extent that the Biden administration is free to change what the Trump administration did, if heaven forbid Trump comes back, or someone with a different philosophy from Biden's comes back, they have a pretty good opportunity to make changes. I'm not sure that too much can be done without statutory changes to really as an administrative matter to enshrine regulations. If Congress changes the law in certain ways, it can certainly cabin the administrative discretion of other of future administrations, and that's probably the best possibility in terms of limiting what a future administration can do. But in terms of if the law stays the same, just as Biden can change things, a successor can also change things. So it would really be up to Congress to sort of enshrine what was done, I think.
Great, thank you. A question came in for Hannah. In terms of reviving a version of the Clean Power Plan, how does the Biden administration best thread the needle by fully capitalizing on the DC Circuit, striking down the Affordable Clean Energy Rule, while at the same time avoiding adverse rulings in a Supreme Court that is skeptical of administrative power? So, wow, that's a doozy.
Well, it's a great question, and I think that's the question. That's certainly the question everyone's asking. I think we're not going to see EPA heavily rely on the DC Circuit's ACE decision, which was, basically laid the track and said you have flexible authority under Section 111D to use beyond the fence line strategies to limit or regulate emissions from power plants. But again, there's no assurance that the Supreme Court is going to agree. And so what I think we're actually going to see is EPA exploring every single vehicle, whether it's Section 111D or another statutes, but they're also, I think, administration-wide going to lean into this government-wide approach that President Biden has really emphasized in the environmental executive orders that we've seen come down the pike. And so I think we're looking at kind of a menu of actions that will be used to regulate power plants. We now have a majority on FERC. And by we, I mean Democrats, and we, I mean Hannah Perls as an individual, I represent myself in that, not Harvard. But I do think we're going to see a lot of positive changes at FERC in terms of reducing greenhouse gas emissions. I also think you're going to see a reliance on environmental justice priorities as a way of increasing enforcement and reducing those emissions, because there is such an emphasis, not just on beyond the fence line approaches, but ensuring that these really old polluting plants that lead to extraordinary and debilitating health outcomes for the surrounding communities are directly addressed, as opposed to cap and trade mechanisms, which might allow those plants to continue emitting and purchasing offsets or whatever the case may be. So I think you are going to see renewed standards from EPA. I don't think they're going to really rely as heavily on that DC Circuit opinion. And I think they're going to try and play it pretty safe with SCOTUS because we don't have a lot of time and we can't afford to get something thrown back.
Great, thank you. And I have a question for Sandy. So, and it's about executive power, which was the topic of the earlier panel also. So maybe this will help us put some of the earlier panelists' talks in perspective. So the question is, with respect to executive power and natural resources, whether it's wielded for conservation purposes or for extractive purposes, is that power ultimately destructive just because it's too big? So is it, is it possible to have executive, a great deal of executive power and that not function, to undermine or undercut environmental values in one administration and then greatly benefit them in the long run? Or, is it more beneficial in the long run for environmental values to have a balance of powers?
Yeah, that's a great question, and I'm not quite sure how to dissect it. There's a lot there. I think one of the arguments that I make in my chapter is that taking measures that conserve and that preserve options for the future are more palatable substantively. Now, I admit I'm biased. I much prefer conservation-oriented executive orders, and I like the fact that they really place a protective layer on our public resources, particularly when it comes to public lands and natural resources and wildlife. Those are public resources. And I think Roosevelt was he very firmly believed that he was acting in the public interest, and he was kind of religious about it, protecting the public's interest in these resources. That said, he was a zealot just as much as President Trump might be said to be, and wielded these powers with very, very few checks or balances. I think it's more troubling now in the Trump era because Trump took so many of these measures to disable or sidestep the agencies, which have since been established for the purposes of procedure, due process, and reaching better, not only involving more meaningful public participation and judicial review, but also reaching better results because agencies are in place because of a certain level of technical expertise. Now, of course, SCOTUS is skeptical of agencies' expertise and likes to exercise pretty exacting scrutiny through Chevron or through the arbitrary and capricious standard or what have you. But we at least have that infrastructure in place. And I think if the executive branch, particularly the president, directs the agencies to engage in more regular and robust rulemaking and to do it before the very end of a presidential term, I know that's asking a lot because administrative processes take a very long time. And of course, there are things such as agency capture by the regulated entities. But still, if rulemaking once again becomes more regular, more scientific, less suspect, I think it can address many of these concerns.
Great, that was fantastic. So I have another question that's for each of you, which is to identify what you, in your opinion, what you think is the most environmentally, like if there's one environmentally damaging act that the Trump administration took that the Biden administration should focus on trying to undo or redo, if you had to pick one, what would that be for each of you? And if you think it's not a fair question, you can pass on to the next panelist. So let's start with Mary.
Sorry, I just had to unmute. That's a good question, and there honestly are too many to pick from. It was an incredibly destructive 4 years. I think one that I would point out is the rollback to NEPA regulations, because NEPA really frames how a lot of agency projects are conducted. And honestly, eliminating requirements for cumulative impacts and really limiting what type of impacts need to be reviewed and who needs to review them, and giving more power to those groups that are to the organization reviewing is just very undergoes, and rolling back those regulations means that you could push through projects without really fully considering the environmental impacts. So that is one that I would bring up.
That's a great one. Did we lose Joel? Let's go to Hannah next.
I'll add another vote for NEPA and the CEQ regs, and certainly the individual NEPA regs that agencies issued. Thankfully, the other one I was thinking of has been struck down, but the secret science rule, I think, was just incredibly debilitating in its design, and it would have severely limited the agency's ability, and here I'm talking about EPA, to issue health-based regulations, particularly when it comes to sort of those categorical, sorry, my brain had a glitch, but the pollutants that we don't think about very often, but really lead to deleterious health impacts, so particulate matter and ozone, that are regulated under the National Ambient Air Quality Standards. So thankfully it was struck down, but that's not to say that future administrations won't try to pursue a similar strategy, albeit under a different statute. So something to flag.
Great, thank you. Sandy, how about you?
I got to join the NEPA bandwagon too. NEPA is just such a foundational charter of our environmental protective scheme at the federal level. It's just so important. And so many of the changes will hopefully be changed back by the Biden administration. But since my topic is executive authority coming directly from the president, I got to say the national monument diminution of 85% of Bears Ears, for example, is egregious both from the substantive standpoint. There are immense natural resources and cultural resources in that area that are now excluded and highly vulnerable to uranium mining, oil and gas exploration, and all kinds of other extractive activities. But it's also from the tribal sovereignty and tribal relations standpoint is also horrific, because it's the first national monument that was proposed by a coalition of tribes and that President Obama saw through with consultation with the tribes. And to just blow that completely out of the water is astonishing. So that's the one that I would point out as, you know, winning the stinker prize of the Trump administration.
That's great. And that's a quick one, right? The president can just sign the proclamation in his office and then move on to the NEPA issue. So Joel, do you have one for us? Your top pick? I'm not sure. Maybe, are you muted? I can't hear. Well, maybe he's having trouble with his audio. Okay, so I had, while we're waiting to figure that out, I had a question about, are there any Trump era regulations that the speakers think are particularly suited for congressional action under the Congressional Review Act? So does anybody have, I'm sure Joel has something to say about one of those. Hannah, do you have any that you would identify?
Yeah, can you hear me okay? Yeah, my connection dropped for today. Can you hear me?
I could hear you there for a second. Now it seems like it's cut out again. You're in Florida, right? They should have decent internet down there. Okay, I can't hear you. Hannah or Mary or Sandy, do any of you have any thoughts on prospects for the CRA?
The only one, again, that I would throw out would have been the secret science rule, but I think in general, we need to be really cautious with the CRA. I know it's been kind of the fun ball that everyone wants to throw around right now, but because of the ambiguity around what would be substantially similar and this question of whether or not it's judicially reviewable, I think we have to be really, really cautious about where we allocate also congressional resources in terms of decision-making and political capital. So For now, nothing really jumps out at me as being worth the trouble of going down the CRA route.
I would echo the same. I think you have to be very careful around the CRA because you don't want to throw something out that could have something that was good or even similar in it that you then can't reintroduce. So, and it also the political capital, there's a narrow, razor thin margin right now, right, in the Senate. And so it's just best to go through the rulemaking process and do everything transparently and make these rules better from the rulemaking process.
Great. Sandy, do you have anything you want to add?
Well, sure. Can I be the dog in that manger? I think if the NEPA regs fall within the 60 working days, I'm not sure they do, and that might be an open issue. I'm obviously cognizant of the political ramifications and concerned about the political ramifications with both the House and Senate, particularly the Senate, on such a razor's edge in terms of Democrats being in control. But I think that the NEPA regulations, if anything, that Trump issued toward the end of his administration should be scrapped. I'm not sure that there's anything worth keeping in them, anything that we would be concerned about wanting to reintroduce and pass again through regulations. I could be wrong on that. I mean, the previous regulations are from, 1982? So it's not that they can't use some improvement as well. But in this one instance, with the Trump NEPA regulations, I think I would just go ahead and throw out that baby with the bathwater. And if it falls within CRA, what's good for that goose is good for the gander, right?
That's great. Okay, thank you all. So I think we're coming to the end of our allotted time for the panel. So I want to thank all of the panelists so much for joining us here in Vermont remotely, and for everyone who's listening in tonight. Thanks for joining us for this panel. I wanted to mention that everyone should please come back tomorrow for evening 2 of the symposium. So the separation of power panel, which starts at 4:30, which I'm actually moderating. And then after that, we have a keynote address with Senator John Tester from Montana. So we look forward to welcoming all of you back tomorrow and discussing more about the Trump administration, starting at 4 o'clock tomorrow, Eastern time.